Crave your indulgence, everyone. We will restart in a few moments for those who are in chapel. Good evening, everyone. Brothers, sisters, and friends, welcome to the second Bethel Legal Aid Clinic public session. Today's session is entitled Land Matters and You, Owning and Securing Your Property. We are happy you have joined us in chapel and in the virtual space to be a part of our panel discussion. I am Richard Hemmings, and it is with great honor that I am privileged with the task of being your moderator this evening. The Bethel Legal Aid Clinic has been in operation for more than 20 years. We are proud of the work done by our attorneys and administrators who provide legal services to the public on a Saturday morning from 10 to 12 p.m. right here at Bethel. Since the pandemic, we now offer a virtual clinic where we meet with persons by phone or by Zoom, in addition to the face-to-face meetings. Friends, for most people, buying their home is the single largest financial transaction they will complete in their lifetime. And yet, we have all heard heart-rending stories of persons who have lost their life savings after buying a property from someone who had no authority to sell the property, or other persons who have bought and occupied their property but are unable to enjoy peace and quiet in their home because of noisy neighbors. Our panel of renowned attorneys, Calicia Finley, Senator Sophia Fraser-Binns, and banker Claudine Murray, will present to us on various aspects related to owning and securing your piece of the rock. Ms. Finley will start off with land and the law, making sure that we understand the basics. Ms. Murray will help us to understand how we can get financial assistance to purchase property. And Senator Fraser-Binns will help us to understand how we can protect the property we have purchased. We look forward to 3 great presentations. After the 3 presentations, we will be opening the floor for questions from the audience. Our audience in the chapel will use a mic which will be placed in the middle, and our audience online will be able to drop questions in the chat room. Before I go on to introduce the panelists, Ms. Calicia Finley, who will come first, let us seek the Lord's guidance and blessings in today's session. Let us pray. Dear Father, we thank you for this, your church, Bethel Baptist, and the many ministries of this, your church, and the ministry of the Legal Aid Clinic. Father, we thank you for this panel discussion and your purpose for it. We know that when we gather together, you always have a divine agenda. We love you for that, Father. And we ask that even now, when we have done what you have asked, the results are much greater than we ever could have imagined. Our prayer today is that your will be done through this panel discussion. Take what we have prepared and multiply our efforts as well as you can. Steer our intentions to align with your righteous will. Remind us of your faithful provision when our efforts fail us or fall short. May all glory go up to you when we come to the end of today's session. Blanket us with your peace today, Father. Keep us physically safe and guard our hearts and minds from pride and selfishness. In the name of Jesus Christ we pray. Amen. So, I will now introduce our first presenter, Miss Calicia Finley. Miss Finley is a managing partner in her firm, Brown, Finley and Company. She also hosts a program called Land Solutions along with Miss Gloria Brown. That's a program on Power 106. She's an arbiter, a Supreme Court of Jamaica approved mediator, and I'm told she's fluent in Spanish. She was admitted to Jamaica, the Jamaican Bar, in 2005, having successfully completed her Bachelor's of Laws degree and certificate in legal education. Calicia possesses extensive knowledge and understanding of the law and is particularly experienced in the area of conveyancing and estate planning and settlement. Her other areas of practice include litigation, first registration of lands, adverse possession, applications in matrimonial proceedings, and complex negotiations, commercial law, contract preparation, providing legal opinions on a variety of matters, and the drafting of registration of mortgages for financial institutions. Calicia has excelled in academia, where in addition to her legal qualifications, she possesses a Master's of Law degree in dispute resolution from the University of Missouri, Columbia, and a Bachelor's of Arts degree in Spanish and Political Science from the University of West Indies. She also has numerous hours of training in mediation and collaborative law. Calicia is a trained mentor with Youth Opportunities Unlimited, a teacher at Sligoville Baptist Church Institute, and a volunteer mediator at the Dispute Resolution Foundation of Jamaica. She's also blessed right here at Bethel, being a volunteer attorney at the Bethel Legal Aid Clinic. We pray that the Lord will speak through her this evening, and so we welcome you, Miss Finley, and invite you now to come and share with us.
Thank you for the welcome, Richard. Good evening, everyone. The significance of land to us as a people cannot be overstated. If we go back to when God created Adam and Eve, God created them, and where did he put them? In the Garden of Eden, to work the land and to take care of it. God promised Abraham land. We see land transcending to Moses, leading the Israelites out of Egypt to the promised land. And now here we are, all working, hoping to get back to the promised land one day. And the same can be said about us in Jamaica. Nothing, absolutely nothing, if I'm wrong, let me know, nothing evokes as much passion in Jamaicans when it comes to land. Every one of us has some relative, if not us, in the country, some grandfather leave a piece of land, great-grandfather, and we're fighting over it. Nothing. Everybody knows the concept of dead left. I don't know if it was because of slavery where we were denied land. We got a little taste of it in emancipation, and we know that land means power. So as Richard said, every one of us wants to own a piece of the rock. And it's because land means so much why it causes so many problems, particularly because a lot of people don't know their rights when it comes to land. So today I want to touch on land and the law. To be honest, I could be up here for 5 hours talking about land law and land matters. So I'm going to try and be as brief as possible and touch on some key pieces of legislation dealing with land law in Jamaica. So I'm just going to speak on about 5 or 6 acts and maybe some laws passed by the courts. The main acts I'm going to speak on are the Registration of Titles Act, the Wills Act, the Intestate, Estates and Property Charges Act, the Limitation of Actions Act, Property Rights of Spouses Act, and the Rent Restriction Act, time permitting. So, the Registration of Titles Act. This really is the Bible governing land law in Jamaica. It deals with registered property, and that's property for which you have a registered title, as opposed to property for which you don't have a registered title. Many of you would know about common law title. That's a piece of paper you have for your land in the country where you don't have a registered title for. So everybody wants to own property. But how do you own property? We want to provide for our family. So a lot of us want to add someone to our title. And we all hear these terms thrown around, joint tenants or tenants in common. But what do they really mean? So when you are purchasing property, when you're acquiring property with someone else, you have to consider how you want to own the property. And this is what I tell my clients. What do you want to happen to your share in the event you die before the other person on the title with you? When you own as joint tenants, we have what we call the rule of survivorship. So we have A and B on title. If A dies first, B gets everything. That's joint tenants. Again, A and B on title. So if A and B are on title as joint tenants, A wills her share to C. That portion of A's will is invalid because with the joint tenancy, it's the rule of survivorship. As opposed to tenants in common, A and B own as tenants in common, the surviving party doesn't automatically get it. So think about it again this way. What do you want to happen to your share if you were to die before the other person on the title? Practical example, I should say. I see this happening all the time. Husband and wife, they buy a property. They buy it as joint tenants. What happens, however, let's say wife dies, husband remarries, husband puts new wife on the title, husband dies, now everything belongs to new wife. What happens? The children of the first marriage are upset because they said, listen, this property belonged to my parents, I must get something out of it. That's not the case. With the joint tenancy, the surviving person gets everything. So again, and actually that is one of the reasons that causes a lot of conflict in Jamaica when it comes to property. Relatives, especially adult children, they feel that once their parent owned land, that they're automatically entitled to it. They're not. When you own as joint tenants, you can also change. You can change from joint tenants to tenants in common and vice versa. You can change as many times as possible if you both agree. If you don't agree, you might have to go to court to do what we call a severance of tenancy. A lot of us want to provide for our children. So when you're buying property, you automatically think, all right, let me put my child on the title. But it's not necessarily a good idea to put a minor on a title. One, if you put a minor on a title, the registrar of the titles office automatically puts a block on the title. You can't do anything with the land until that minor becomes 18. But how you can get around that is to put what we call a reservation clause on the title. So meaning, adult mother owns the property with child, but mother has the power to do anything she wants with it. So that's one thing to consider when owning property. Also, in wanting to provide for our families, a lot of people, and I'll get to estate planning soon, a lot of people in planning their estate, they want to add their children to the title. It can be done, but there are certain things you have to consider, especially when it comes to NHG benefits. If you put your child on your title, when the child comes of age now and they go to the NHG to try to apply for a loan, NHG may say, no, we're not lending you any money. We can't give you all the money you're expecting because you already own a property. So that's something you need to consider. Again, when you're buying property, you have government duties, transfer tax. Transfer tax is generally 2%, and a lot of people think that once you're adding, let's say your child or your spouse or another relative, once it's by gift, that you don't pay transfer tax, but you do. There's always transfer tax, which is 2%. It's much less now. In the past, it was 5%, before it was 7%. There's also what we call the Special Provisions Act, where you can get a reduction in the transfer tax. So their transfer tax is based on the tax roll value as opposed to the market value of the property. Let's talk a little bit now about estate planning, the Wills Act. What is a will? We take it for granted, but a will, simply put, is a document that states your intentions and what you want to have done with your property after you die. A will only comes into effect after you die. A lot of people think that as soon as they write the will, mommy writes her will, she wills her property to her son. Son believes that as soon as the will is signed, the property is his own. Absolutely not. The will comes into effect only after the person who is making the will has died. Compare a will now with a power of attorney. A power of attorney is a document giving someone power to act on your behalf. The power of attorney is only while you are alive. So power of attorney during life, will after death. Countless times people come to my office and say, my mother has died, but I have a power of attorney and I want to do ABC. Nothing can be done. Once the person dies, the power of attorney ends. So don't just rest on having a power of attorney. Do a power of attorney and a will. You don't necessarily need an attorney to do a will for you, and yes, I'm an attorney and I'm saying that, but it is advisable to have an attorney prepare a will for you. You don't want to make any mistakes. If you choose not to, you can buy a will form in any bookstore or pharmacy, but get a will done by an attorney. Interesting question, which falls under the Inheritance Act. Do you have to leave something for your relatives in your will? Technically, the answer is no, you don't have to, but there is a tricky provision in the Inheritance Act that says that if someone feels that they were unreasonably left out of your will, if you used to take care of them, if they're your spouse, if they're your child, they can challenge the will. So, but you, as I said before, you don't have to leave something for your spouse. If you deliberately want to exclude a spouse or a loved one from your will, say why. Say, I am deliberately not leaving anything for my daughter because while I was alive, she was not a nice daughter. Let me not use colorful language, but you can't say that. All right, continuing with estate planning. We all want to make provisions for our loved ones, but how practical is it? What sense does it make for you to make a will? Next slide, please. What sense does it make for you to make a will, but then there isn't enough money in your estate to carry out your wishes? So, what happens frequently? Mother may will her house to her daughter, but there isn't enough money in the estate. And because of this, can we have the next slide, please? Thanks. And because of this, if the executors don't have enough money, the executors can go ahead and sell the property, meaning that the person's wishes won't be carried out. So it's all well and good to make a will, but again, do you have enough money in your will? Consider having an insurance policy. With an insurance policy, as soon as you pass away, your beneficiaries have access to those funds, and they can use that to bury you. Sometimes having an outdated will is just as bad as not having a will at all. Someone will come to me and say, yeah man, I have a will. All right, how old is your will? I have it from 1990. When you look on the will, although those properties no longer exist, the persons named in the will are no longer alive. So keep updating and anytime anything changes, you sell property, someone dies, update your will. I had a client, God rest her soul, I'll refer to her as Miss Mary, and I'm not exaggerating. I did about 20 wills for her. About every month or two, I would come into office on a Monday morning and see her waiting on me patiently. Say, all right, Miss Mary, who you vexed with over the weekend now you want to change your will? I didn't even bother to charge her again. So be like Miss Mary, keep updating your documents. All right, what happens when you don't make a will? The law that covers this is the Interstate Estates and Property Charges Act. Fancy, long term, but in short, what happens when you don't make a will is that the government decides who gets your property. And I'm almost certain nobody here wants the government to decide who gets their property. Let's say you are married, but you are estranged from your spouse. You haven't seen them in over 20 years. If you die without a will, your spouse can get your share of the estate. So make a will. And a lot of us as Jamaicans will say, oh, if I make a will, I'm going to die. I don't have anything to leave in a will. It can't hurt you. Another common and unfortunate scenario, we may have a close friend, or we take care of a child who we love as our own, but we didn't go through the formal process of adoption. And of course, we would want that child to benefit in the event that we die. But if you don't make a will, the law will say that they have nothing to get. So please make a will. Let me just rush on to the next slide, the Property Rights of Spouses Act, this lovely act. In short, this act says that each spouse is entitled to a 50% share in the matrimonial house. Who is a spouse? We know a spouse is someone you're married to or someone you're living with for at least 5 years. And this causes a lot of debate. It's what we call the family home, the house that you live in. So if you have two houses and you're back and forth between them, only one can qualify as a matrimonial home. If you live in a house with your spouse and only that spouse's name is on the title, it still qualifies as a matrimonial home. But there was a recent decision by the courts that says the Property Rights of Spouses Act cannot come into play after the person has died. So if you are in a situation where you have a spouse, but your name is not on the title, it's best for you to act on it and get your name on the title while your spouse is alive. And the good thing with the Property Rights of Spouses Act, to add your name to the title, you don't pay any transfer tax. I think all you pay at the stamp office is $100. So try and get that done. There are ways to get around the Property Rights of Spouses Act. You can do a prenuptial agreement or a postnuptial agreement to say you don't want anything to, and for parents too, let me just say this quickly. Let's say you are leaving a property for your child, and you don't like your son-in-law, or you don't like your daughter-in-law, so you don't want them to benefit from that property. You can specifically state in your will that, yes, I am willing this house to my son, but I do not want his daughter to get a share in it under the Property Rights of Spouses Act. Another act that governs land in Jamaica, two of them really. Again, the Registration of Titles Act and the Limitation of Actions Act. Squatters' rights. We all know about squatters' rights. Depending on which side of the fence you're on, no pun intended. The law says, and Ms. Fraser-Baines will get into that in more detail, you can claim title just by being on the property for 12 years. You can. A lot of us, especially those of us in the rural area, we have property, we're just not doing anything with it. We're just sitting there. We only decide to act when someone tries to take us off. So if you're in a situation like that, get the property surveyed. Get 2 people who can speak to the 30-year history of the land. Get your supporting documentation, any old documents, water bill, light bill, to show that you have indeed been there. When you are applying for title, you have to show that the property taxes are up to date, but a lot of people make the mistake and think that paying property taxes alone is sufficient. It isn't. So you'll have people here in Kingston, all the way in the UK, religiously paying the property taxes every year for decades, only to find out that somebody has been living on the land, farming it, and they're entitled to the title. So don't make the mistake of thinking that paying the property taxes alone is sufficient. Landlord and tenant. The law that governs this is what we call the Rent Restriction Act. And unfortunately, it came about at a time when there was protection needed for tenants. So now the law really is skewed in favor of tenants, and landlords are pretty upset about it. So let's say you want to get a tenant out of your property. You give them a notice, time expires, they're still there. A lot of us would think, all right, the notice has expired, I can just go in and take them out of the property. You can't. You have to go to court, seek an order for what we call recovery of possession, and that can take several months. When you get that order from the court for recovery of possession, and the tenant is still there, you say, all right, yeah, man, yes, I can go in now and drag them out. That is illegal. You still have to go back to court to get an order from the bailiff to get them out. So make sure you know the law. If you have any issues with your tenant, with your landlord, you can go to the court, or you can go to your rent assessment board, the rent assessment board. And just one final thing. We know there's a lot of fraud out there, a lot of scamming, and a lot of tenants use renting property as a guise for laundering money. So be very careful when you're choosing your tenants. Do your due diligence. Get your references. See where they work. Get their addresses. You cannot be too careful. And again, when it comes to anything to do with land, please ensure you seek an attorney first, especially when you're buying land. Don't pay any money directly to the seller. Pay money only to attorneys. Thank you. I'll get back to more shortly. Time is up on us.
I'm hoping we have learned some things. Reservation clause, special reduction tax. I need to talk to you on that one. Keeping up to date with your will. Don't just write the will and leave it there and think it's okay. Make sure to keep it up to date. And of course, squatters' rights or adverse possession. Paying your taxes is good. Give to Caesar what is Caesar, but a part of getting that adverse possession is being in control, being in possession of the land or in control of whoever is there. So pay your taxes, but make sure you're in control of what's happening there. Thank you very much, Ms. Finley. I've taken some pointers here, which I'm certainly grateful for. So, I am going to introduce our second speaker for today, who will give us a little snippet into the financing as it regards to securing land, purchasing land. Ms. Claudine Murray is a career banker with over 25 years of experience within the local financial sector. The last 7 years, she has been in the corporate and commercial banking. She's the holder of an MBA in banking and finance and has a Master's of Arts in teaching, adult education, specialization. Ms. Murray has a track record of successfully managing and creating value for clients in the retail and commercial banking segments. Her primary responsibilities of managing a core portfolio of providing advice on products, services, and strategic business needs. She describes herself as a solutions superhero for all who are her customers. With a passion for finance and professional salesmanship, her goal is to provide expert guidance to each client, to work diligently with them to achieve their financial goals, and to guide them in making informed decisions that suit their unique situations. She will help you find the way. Ladies and gentlemen, may we welcome Miss Claudine Murray.
Good evening, everyone. Superhero. Okay, so you have decided to buy a house. Congratulations. The road ahead will be long and requires patience. I bought my first home many moons ago, and that's when I learned patience. Buying a home can seem complicated, but you should not hesitate to ask your mortgage representative, whomever that is, several questions. Up on your screen is a segment I've entitled Assessment. This is usually the longest aspect of the financing process. I might not refer to it regularly because I'm going to be asking you to just think about some things in your head as I go through. The first thing is, what is the down payment and why is it required? I've found this property, I'm ready, I'm excited, let's go. So most persons, well, still do, because there are persons who go the route of cash. But let us think of persons who go the route of getting a mortgage, which is what most persons do. What is a mortgage? A mortgage is a loan that the borrower uses to purchase or maintain a home or other forms of real estate and agrees to pay back over time, typically in a series of regular payments. And I'm emphasizing regular payments because when the payments become irregular, that's when we start to have trouble. And I think Alicia referenced it. Your mortgage is your property is your most prized possession. You don't want to fall into the bracket where, we have to be calling you in and trying to work out how do we get back to regular business. So, can I afford a mortgage? Oftentimes, we identify the property, we get excited, we tell ourselves, yeah man, I can do this, it's me. Whether it's a $20 million property, so I'm gonna join with somebody else, and I'm gonna get my NHG, is it 13 million, right? 6.5, 13 million. And then, as Calicia said a while ago, you go to NHG, and NHG says, I'm sorry, your name is already on a title, and so you can't get your full 6.5. I know there's been discussion to kind of change that or to get around that, but that requires you going in and saying to NHG, you know what really happened? My mother really wanted to protect me, so she put me on the title when I was only 10 years old. Now I am 35 and I'm ready so you have to prove to the NHG that you were really added to this title and it's not yours in its truest sense in order to get your full $6.5 million. What I find that they will do as a compromise, if it is that you can't fully prove to them that you were only added, you will get something, but you won't get the full 6.5. So again, do I have the down payment? Am I ready? What does the process entail? So one of the first things I always say to persons, ensure the persons you are buying a property from are the persons legally able to sell said property. Whether it's a new development, whether it's a second home, ensure the persons you are entering into a sale arrangement with are the persons whom are legally able to sell this property. We have too many incidences where we start the mortgage process, you do a title search, or you reach halfway, you reach almost there, and then somebody appears one day to say, I'm sorry, this title is a forge, the persons who entered or signed the sale agreement, I don't know them, and you get into one other legal ramification, right? And yes, I know my learned friends to my right advocate, yes, for attorneys to be involved in the process. Please choose wisely. That's the most I'll say on that. We hear about it regularly. Choose wisely. Nothing bad with my people over here. All right? So what do you do first? Of course, you're going to try and find your financial partner. I'm not going to say find an institution, find a partner, because it's going to be a partnership for the long term. Find partnership that can help you or guide you every step of the way, right? So one of the first things we look out for, if a sale agreement or if a person comes in front of us and the vendor and the purchaser has the same attorney, red flag. Not that it can't happen. We've seen it happening. I'm sure in the legal sphere maybe it shouldn't happen, but we see it. I always say red flag. Have an independent party acting on the purchaser's behalf, have an independent party acting on the seller's behalf, so that you have all those minds clear. We spoke about having access to your NHT benefit already. The other thing is, do you know what real estate prices are in the area which you have identified? And I'm asking that because sometimes areas or what you're buying is overpriced, and say you buy something that is overvalued, and so that's one of the reasons why we ask for an independent valuation. Some institutions ask you to get the valuation and come in, while other institutions get an independent valuator. Because what some valuators we find will do is valuate for what you want. But at the end of the day, is this what the property really values, one, and is this what the area in which you're going into is valued? And the reason for that is if you get to the stage where you want to sell, you could end up being at a loss because the property really never valued that from day one, right? So we have to be so careful. All right, so we're not going to go into cash or mortgage because I'm sticking to the mortgage side of it. When is the down payment required? So yes, we try to encourage you to have your down payment upfront or identify your down payment. Do you want to pay it over? Some persons may want to have the deposit to secure their interest in what they want to acquire, while some may ask the bank or the institution, whether it's a credit union, BTC, whoever it is, to pay over as part of the proceeds so that you protect your money, because you don't want to put down your deposit, people disappear, property not finished, or the property that you get is not what you identified in the first place. So you have to be very careful when you get to paying over your deposit, even if you have identified that you have a deposit. So that's part of the assessment process. Can I afford a home? That's a question that you really have to sit and ask yourself. Home affordability does not only include a mortgage, the mortgage payment. Most properties now come with maintenance because everybody wants to live into a secured complex. There is your monthly maintenance. There is property taxes. There are strata fees depending on where you are. There's so many, the maintenance of the property itself, the little bits and pieces, because you have to paint, you have to keep up your property, gardening, all the little things. Think through, can I really and truly afford a property? I want to touch on something that we don't stress on enough, and it's about insurance of both the property and the mortgage. I'm separating them. Oftentimes, we are encouraged to insure your property just in case anything happens. However, I'm encouraging persons also insure the mortgage. What does that mean? If anything should happen to you, that insurance pays out the balance owing on the mortgage. Not the insurance for the house, the insurance for the balance of the mortgage or the value of the mortgage. So that way, Mr. Financial Partner was your partner at day one, who will want to be your partner throughout. Doesn't come knocking and saying to the people who have left your children, your family, nice knowing you, mortgage is now in arrears, this is now my property I have to sell so that we can settle the liability. If you have an insurance for the mortgage itself, the insurance should be sufficient to cover the balance of the mortgage, leaving your people free and clear of that liability. Oftentimes, again, as I say, we stress, or the partners stress, insuring the property, but they don't stress insuring your mortgage. Please make note of that. When we're doing our assessment, we look at what we call your debt service ratio. What is your debt service ratio? Your debt service ratio is simply what is involved, your salary, and all the other attendant liabilities that you have to take care of, and then what you will have left to live off. Because we don't want to leave you destitute. I mean, we know times are hard. Everybody wants to pay their mortgage or their rent and those committed bills first, but then you pay it, and then you can't eat. You pay it and you lock up in the house and you're just crying every night. We want to ensure that when we're assessing you, you have residual funds left to live comfortable. So that's part of your debt service calculation. All right. The other thing that we must look at in our assessment or in acquiring a house is, this is the funny one. So you come to your financial partner, we do a title search. And a title search will tell us whether or not there are caveats on the property. And that is a big one, because a caveat can be on a property and the person doesn't know. Well, it should know, but we have seen too many incidences where caveats are there and you don't know. And sometimes caveats are placed by your own family. Let's say it's a family house, and I was giving an example earlier. Brother gave another brother the family house to live in. Brother decided to add a bathroom, add a kitchen, so we no longer have to go outside. We come in now. The other brother, the owner of the property, is ready to sell, and brother, who has been there for years and added value to the property, puts a caveat to get back what he called his equitable interest. Yes, there are ways to work that out, but you don't want to be working that out during the mortgage process. So we do the title search up front to ensure that the titles are free and clear to start the process, right? Surveyor's report, I mean, that we cannot overemphasize getting all of these legal things done. You don't want to be buying a property that is quoted as 1 acre in the sale agreement, and when the surveyor's report is done, it's a 3/4 acre or half acre. And then you start to wonder, where's the other? Well, that's what the surveyor is saying. No, did you do a surveyor's report? The other thing is proof of identity. We want your true proof of identity. We have seen too many cases where Tom Stroke comes in front of us, and when we get to the point of disbursement, Tom Stroke becomes Daniel Brown. We see that. We know that. Come to us as your true self. We don't want the problems at the disbursement stage of a mortgage. The other thing in the assessment to approval, if you're going to be joining with somebody else, make sure in the bottom of your belly, your heart of hearts, this is the person you want to enter this important step in your life with, because you don't want to sign off and then 3 months down the line, this person says they were forced to, or they no longer want to do it, and then you're held carrying the bag all by yourself. And even if they should say, I'm over this, again, in your head, can I afford this all by myself? And we're seeing a lot of that now. A lot of properties are up for sale only because a year down, 2 years down the line, I'm out of here, because I find that, and I mean, I'm not against young people acquiring, but they don't deal with stress well. They don't handle stress, so they want out quickly, right? They're not into finding a solution to the problem, sell it and make we go about with business, or they just stand back and make it becoming arrears and everybody who's to lose and they move on. You don't want that. Ensure that whoever you're entering into this agreement with is who you want to enter with. I saw something recently, and I'm going to bring it up just in case my learned colleagues don't. We're seeing too many cases where, especially us as women, and it's not that we're not intelligent, you go into the home, you're married, there's a roof over your head, but you've never asked to see the title. Yes, because in your mind, this man married you and put you in a house. And then the house has a mortgage on it. He passes or, something happens and we come knocking and you are not aware. Because some people just don't ask questions. And they find it almost intrusive when we start to ask questions in the assessment process. And I was embarrassed at one point where I did the half and half, husband and wife, on a mortgage application, and the gentleman pointed out to me that the person who I gave a 50% really only owns 1/8. Never saw that on the title, and it was clearly there, properly divided in fractions. So from time to time, just ask, nicely, who, what, some sort of discussion, high level, so you're comfortable with what you're buying, what you own, what you think you own, or what you think you owe. Because sometimes you don't even know you owe what you don't owe. Lastly, credit report. I'm going to stress on that one. That is now a requirement or should be a requirement with all financial partners who you enter into agreements with. First thing we're going to ask you to do is sign a consent for us to go to the credit bureau to check on your credit. And I'm going to tell you why. A lot of our utility companies, the student loans, can file something at the credit bureau and you don't know. And these things will affect your credit rating. Of course, fees. Fees are a big thing. I say to people, 15 to 20% of the value of your property, please put that aside. So this is not your down payment now. Down payment is usually about 10 to 15%, depending on who it is, could be 5 too, but another 15 to 20% to cover all the different fees between the partner and the legal fees, because the government has to get their share. A lot of it is not ours, it's for the government, and it is required. Thank you.
Wow. The financing as it relates to property is not a thing to just look over. Ensure you're buying from the owner. It's advisable that you have an attorney, and I'm advised, choose wisely. Ensure to get that V word, valuation. You have to know the value, not just what the owner say it value, but what the market demands of the property. Ask yourself before you buy it, not because it's advertised as X and you say, well, I have the 5%, I can afford it. Can I really afford this house? You have things like maintenance, insurance. And I'm thankful for learning that there are two types of insurance. Insurance for the property itself and for the mortgage itself. Make sure you speak to your insurance broker so that you are fully covered in that way. What is a caveat? Don't be surprised when you're doing a sale or purchase of a property that a caveat comes up. Make sure that you do a surveyor's report. Call it buying pussy in a bag, but they'll say it's 1 acre when it's really 3/4 acre. So make sure you get your valuation, you get your surveyor's report. Please, these are not things you just say, I'm going to save on these costs. I don't need a lawyer, I don't need no surveyor, I don't need no valuator. And you say you're going to save, you're taking somebody's word for it. These are the things we're learning here to save us from partake. Thank you very much, Miss Murray. I will now share the introduction of our final speaker for this evening. Miss Senator Sophia Fraser Binns is an attorney at law with over 17 years at the bar and has enhanced capacities in strategic planning, program management, child rights, and advocacy. A graduate of that great Westwood High School, Sophia obtained her Bachelor's of Law degree in 2003 from the University of the West Indies, Cave Hill, and has a certificate in legal education since 2005 from the Norman Manley Law School. She also holds a Master of Laws degree in entertainment from the University of Westminster, London. She practices in areas such as conveyancing, estate planning, and administration, and she's using her master's in the area of entertainment law. She also holds a Bachelor's of Law and Bachelor's of Science in International Relations and Public Administration. In 2013, she was appointed as senator, a position which she continues to hold, and is the opposition spokesman on land, environment, and climate change. She has worked in the community and youth developed sectors and started the legal aid clinic at the St. Matthew's Anglican Church. She is married and has 2 wonderful sons. I put wonderful there. Ladies and gentlemen, friends, it is with great honor that I introduce to you to share with us Senator Sophia Fraser Binns.
Good evening, everyone. So you have seen a property that you really, really like. Maybe somewhere in Brownstone, where I am from, and you really like it, right, Kelly? And you went to Claudine, and Claudine said, yeah, you qualify. You went to NHG, they said, yes, you can get your 6.5 million. So you said, yes. But you need a good lawyer. So you went to Gloria Brown, and you saw Miss Finley. And they said, Miss Finley, I need your help. And with her professionalism, you became a landed proprietor, as we call it, or you had your first investment and your home. So now that you are a registered owner, the question is, how do you protect this? When I was asked to speak on this topic, I said, well, this is so wide. I can speak on so many different aspects of it. I can talk about protecting your property in terms of, grill from thieves. I could do that, right? That's one way of protecting your property. I said I could also talk about protecting your property in terms of an insurance, but then again, Claudine already spoke about it. So I said, you know what? Let me talk to you about protecting your property from other people owning your property. And so today, I want to talk to you a little bit in 10 minutes about trespassers, or what I want to talk to you about is adverse possession. Now, what essentially is adverse possession? Simply put, it is really where someone moves onto your property without your permission and takes control of it. And that control has to be for a specific number of years, which I'll get through in a minute. Well, what does the law say about adverse possession? Essentially what it says is that any person who claims that he has acquired a title by possession to land under this act, which is the Registration of Titles Act that Ms. Finley spoke about earlier, can apply to the registrar to be registered as the owner. In other words, if you claim that you are the owner by possession of a property belonging to somebody else, then subject to certain requirements, you can apply to the titles office to become the owner of that property. But what is interesting is that you being the registered or the legal owner can only get that person off your property if you do that within 12 years. You can take that person to court for rent, or for recovery of possession, but it has to be done within 12 years. So if after 12 years you decide that John Brown is on your property, well, I'm sorry to tell you, but there's nothing you can do because you would have lost your right. And that is what is provided in it. But what are some of the things, apart from the 12-year rule, that you have to establish? And there are 4 of them. The first of which is it has to be continuous, it has to be open, it has to be peaceful, and you have to have an intention to defeat the registered owner. When we talk about continuous, what do we mean? It means that you have to be in possession of the property for a minimum of 12 years without any interruption. So the registered owner would not have served you a notice to quit. Nobody would have come on to you and said, come off my property. That is what we call continuous possession. And this is mainly for registered property, which Ms. Finley spoke about earlier, where you have a title. But for those where you don't have a title, which we call unregistered property, then it is 30 years. And not for today's discussion, but under the special provisions, Act, if an area is declared a lamp area, then there's some way to deal with it. But essentially, what you have to understand is that your possession of that person's property has to be for 12 years continuously without any disturbance. It should be open and peaceful, which means you didn't go on and fight, or there wasn't any war or anything of the sort. And most importantly, it was done openly. So it is not something that was like a Nicodemus by night, but everybody in the community would have seen that Mary Lou has been on the property and doing certain things and been doing those things for at least 12 years. You also, as I said earlier, need to have an intention to defeat the rights of the registered owner. And when we talk about intention, we're talking about you doing acts that a registered owner or the rightful owner would do. And these acts vary. So it would be something as simple as fencing, or building a wall, or cutting the grass, or something as serious as renting the property to somebody else. Those are acts that an actual owner would do. And once you do them continuously, openly for 12 years, then you can claim to have a property by way of adverse possession. It is also important to note that you going onto the property must be without the permission of the owner. So if it is that the owner gives you permission, whether as a licensee, that is, you stay on the property without paying any rent, or as a tenant and the tenancy lapse, then it is difficult for you to establish on the face of it that you would have gone in without permission. Now, and time is upon us, but there was a very important case that we in the profession like to reference. It's very recent. It's called Recreational Holdings Limited. And in that case, the court ruled that the gentleman, Mr. Lazarus, in fact, had a claim for adverse possession against the company because he had been in possession of that property in excess of 12 years. But what was critical in that property, that matter, was that the property was sold was sold without the knowledge that someone else was in possession of it. And the court said this, that although a certificate of title provides conclusive proof of ownership, so you have a title, so on the face of it, it means you are the owner, a person whose title has been extinguished by adverse possession cannot pass a good title to a purchaser. In other words, you have your title in your hand, and on the face of it, you see your name, Sophia Binns, on it. But then you go and you sell the property to person B. Now, the fact that person C has been in possession of your property for 12 years, continuously, openly doing acts of possession, means that your right would have ended even without your knowledge. And in that case, the property that you sold to person B would be null and void because you really have nothing to sell when you sold your property. And that is why it is so important when Claudine and Callie spoke about doing the title search and making sure that you check to make sure there are no caveats or there's no change in ownership, and that the person who is selling, in fact, is able to sell, not just on paper, but, of course, in law. It continued that A purchaser who was unaware that someone acquired title by adverse possession cannot trump the possessor's title. In other words, if person A acquires title legally through purchase from person B, unknowing that person C has already acquired ownership by adverse possession, person A's right cannot trump person C, who would have acquired it by way of adverse possession. At the end of the day, the critical thing is, having heard about this, how can you protect your property? And I share with you just some rule of thumb that you can practice in ensuring that you protect your property. The first of which is to know that the payment of property tax is simply not enough. Because as the saying goes, possession is 9/10 of the law. There's so many times that I'm sure Callie will share that experience with you as well, that we have persons, particularly those overseas, and not limited to overseas persons, who would have purchased property, and yearly, every March or April 1, they go online or they send the money to Jamaica and they pay the property tax religiously. They have no arrears, they don't pay no interest because they pay the property tax on time. But they have never asked someone to go and bush the place, check to make sure nobody's living there, serve notice, nothing at all. They just pay the property tax and they say, but I pay my property tax. And at the end of the day, they have no rights to it because they've been paying the property tax, but that in and of itself is simply not enough because possession is 9/10 of the law. The second thing is that possession does not equal occupation. So someone may be in occupation of the property, but they may not be in possession. And what do I mean? So the landlord would be in possession. The tenant would be in occupation. The tenant, because he's on the property with the permission of the landlord, cannot claim adverse possession, though he is in physical occupation of the property, because the landlord is one that is in possession. And it is very important that we understand the difference between possession and occupation. And I spoke earlier about acts of possession, things that an owner could do to show possession. And then if you have a tenant on your property and the tenant's agreement expires, just renew it. And you don't have to do a full-scale lease agreement. You can simply have something basic to say that the terms and conditions of the lease agreement of March 15, 2020 continues for another 10 years. Because once you have that documentation to show that the person is in occupation with your permission, then that prevents any claim for adverse possession. Then charge a fee. It is so important that we charge a fee. Because sometimes, you put persons in possession or occupation of your property and you say you're not going to charge a fee because it's a friend or family or you're just doing a good deed. But unknowingly, they're the ones who are building up a 12-year case against you. And at the end of the 12-year, they can say that I'm the owner. So one of the things we've always said to persons, charge a fee, even if it's what you call a peppercorn rate, a $1, $100, $10, just do something to show that you are in fact the owner of the property. Then serve a notice to quit. And especially if you are not charging fee, every year, September 16th, every year you go and you serve a notice to quit. Because what it does is that it stops time from running because there is a disturbance. And remember earlier I spoke about the fact that it has to be continuous. But every time you serve a notice to quit, time starts again. Time stops and it starts again. So at least you serve a notice to quit yearly. And if you have a reserve road, because sometimes your property is such that a reserve road sometimes runs through it or runs beside it that you own. And if you have a reserve road, just once a year for half day, just close it off. Nobody can use it. Because by doing that, you are asserting your ownership for the property. So it's important that you bear that in mind. I'm wrapping up, and I just want to say that adverse possession is very real. We have come across it in so many different cases. We have done applications in our own practice for persons who have established a case for adverse possession. It is something that is real. It is something that is provided under the law. And it is only you as the owner who can really stop adverse possession from taking place. And you can ask, you have the law, you have your family, you have your friends, but at the end of the day, it really rests with you. And I close by sharing a quote from Calvin, and it says, ultimately, property rights and personal rights are the same thing. Their enforcement rests with you. Thank you.
Thank you very much, Senator. Well, squatters have rights too. We have learned that how many years you need? 12 years, undisturbed possession of the land. So if you as a landowner want to ensure that this is not something that happens against you, make sure you serve a notice. Make sure you, if you know who is in possession and it's your friend, you have a peppercorn rental. And we have learned that it is important to ensure to pay your property taxes, though this is not the only thing that exclusively shows ownership of land. So thank you so very much, Senator. We are now entering into our time for questions. And I have so many questions myself. But before I take on my own questions, we are going to open the floor. What you're going to do, you're going to come to the mic, and if you have a specific person you want to address the question to, you can address them, or it can be open to any one of us to answer the questions. Questions that are posted online, they will be fed to me, so you can post your questions online as well. Yes, go right ahead. You can just state your name and then go right ahead.
Afternoon all, I'm Vivian Clark. And I have several questions, but I'll probably just take two so that others can ask their questions. The first question I want to raise is the Wills Act of Jamaica. I don't currently have a will, but all of my little possessions I have on them, let's say my insurance policies or stuff, I have on them who should be the beneficiary. Is that sufficient? And let's say my property, I only have one child. Is it automatic that if I were to pass on, it is known that she would be the person to receive that? That's one. My second question is, that refers to the spouse's thingy. If it is that we're in the matrimonial home, he has a property, I have a property, but he's living in mine. The fact that he has one himself, if it is that there is cause for separation, is there some kind of discretion that will be lent to that scenario, or is it that the fact that we would have lived in mine and he would have lived in that on that property or in that house for over 5 years, is it automatic that he would have some claim on my property? Thanks.
All right, the first question. For your child, is your child under 18 or over 18?
She's over 18.
Are you married?
I'm widowed.
Okay. If you don't, are your parents alive?
My mom is, yes.
All right. If you're not married, you're widowed, as you say, your child would get everything. Mm-hmm. Your parents wouldn't get everything. Your child would get everything. But, and I take the point that you say you already have beneficiaries under your insurance policies, perhaps you have names already on your bank accounts, but it can't hurt to make a will. What if you acquire property and you're not able to do a will? You know, so it can't hurt. What if you have some money coming to your estate? What if you die in an unfortunate accident? You may have some money coming to your estate. Can't hurt you to do a will. Second part of your question now, with respect to your spouse. You have your property, both of you live in it, he has his separate property. How long would he have lived in your property with you? Because the court looks on that. Let's say he's just lived in it with you for
over the 5 years.
I'm sorry?
It's been over the 5 years.
He's been living there over 5
Yeah.
years. It would qualify as a matrimonial home. The court isn't going to say, well, he already has his separate property. No, it's the house that you both live in together.
I don't get it. So you're saying although he has his
Yes,
property,
that
there's no
property,
discretion?
There's no discretion because it's the Property Rights of Spouses Act. It covers the matrimonial home. The matrimonial home is what you live in. The court doesn't look on the other separately owned property.
if I may quickly, final one.
Sure.
My niece lives in a property that I own. She doesn't pay rent because she can't afford to. But
Yes.
what I'm thinking of now, having listened to this discussion, if it was that I were to ask her to pay, but she doesn't pay, are you saying the way I can get over this is to make sure that I serve her a notice to quit every year? That
Yes.
would take care of that.
But you also have to follow up the notice. So when the notice expires, if you really want her out, take her to court.
I don't really want her out because she can't
If you-
afford it.
I
but
understand,
I
but
don't
charge
want
her something. Charge her $1,000 a month. Charge her something. Once she's not paying anything, is your niece and you love her and everything, but she can't take it away from you. So charge her something.
Thank you very much.
You're
This has been
welcome.
extremely informative.
Thank you, thank you.
I have a question here online which is just to follow up on that last question from our sister. It says here, what if my name is not on the title for the family home and my spouse dies before I get my name on the title? How do I proceed?
The spouse didn't leave a will, right? It didn't say?
No, I didn't say.
All right, so as I had mentioned before, there's a recent decision that says the Property Rights of Spouses Act doesn't apply after death. So she wouldn't be able to claim a 50% share of the property under the Property Rights of Spouses Act, but she may be able to claim it by virtue of the Interstate Estates Act. As the wife, she's entitled to a share. She can also have what we call an equitable interest. But please don't wait. If you can now, put your name on the title.
Yes, go right ahead.
Good evening, good evening, everyone. My name is Marilyn Tapper, and I'd like to ask you, Miss Finley. I mean, I did see you mention anything about trust. As you know, I come from the United Kingdom, and we have trust.
Yes.
And there are trusts in Jamaica, for example, the Jamaica College and Woolmer's High School. They are trust, and I see that this trust doesn't seem to be very popular in Jamaica. Can you explain why? The second question is to address to, sorry, can't remember your name, is that it seems to me that where I come from, we can have mortgages up until the age of 100. And in Jamaica, I can't have a mortgage because they tell me that I'm too old. Neither can I even add somebody else who is much younger than myself. And I just feel that's really very, perhaps we need some updating on that, please.
We do have trusts in Jamaica. I just find that a lot of people aren't really informed about trusts. One way, when we're doing
What is a trust?
when we're doing estate planning, let's say you don't want to put your child's name on the title, we can create a trust. And essentially what a trust is, it's a separate document or it's a vehicle that says you hold this property on behalf of your beneficiary. So their name won't be on the title, but it will be in a separate document. There are some limitations. Sometimes a trust can only be done within 1 year of you becoming the owner of the property. In the United States, they have what they call a living trust. We don't have that concept in Jamaica, but we have something similar where we can do a life tenancy. So you can add someone to your title. So let us say mother is on title and she wants to provide for her child. So she can add add child to the title. So the title would now say to mother for the term of her natural life, and after she dies, it goes to the daughter. So that's another sort of kind of trust.
The-
Hello?
I mean a trust that, for example, I have a will as well, but in case I die, my properties automatically goes into a trust. And I can sort of say, this is my memorandum that I appoint Earl Grey to become other people to become a trust, and that's a lifelong. And I can specify in that trust how long that Earl Grey doesn't remain. As soon as Earl Grey gets to 70, someone else is appointed, and that's the sort of practice that sort of goes on where I come from. And I just wonder why that isn't in Jamaica.
It just isn't. It just isn't, I'm sorry. But it's usually done before. It's usually done outside of the will. So it's done what we call an inter vivos transfer while you are alive.
Okay, she had asked a second part of her
Yes,
question
so
with
that's-
remortgage, right?
That's
The
for
older
me.
persons.
All right. Unfortunately, and I say unfortunately, we tie a lot of things in the financial sector to retirement age, because the assumption is that once you get to retirement age, you stop earning. And so while, yes, you can get a mortgage, it cannot go beyond what the law claims or states to be your retirement age. And yes, you can join with a younger person, but the mortgage will go up to when you're retired. So it makes it more, yes. Yes. Because remember, anything can happen to the younger person, and the older person will have to take on that debt. It's one of those things.
Please come to the mic.
Come to the mic.
Good evening, everybody.
Good
Olive
evening.
McNaughton. So are you saying
The mic.
are you saying that I can't buy any more property in Jamaica and take a mortgage? That if I
You
reach-
can. We just said the maturity or the term of the mortgage would be up to when you are supposed to retire.
Which is shortly. That means that even though I may put my child with on that mortgage, I can't do it for more than 2 years.
Law.
Okay.
Law.
Okay, so, but we need to try and change some of these.
Legislation.
So we need to
Legislation.
try and change some of those things. These things have existed for years. Why don't we make an effort to try and change some of those things? Because people are living longer, as you know,
Yeah.
and all of those things. So why don't the lawyers do something about trying to get those acts or those whatever changed? Anyway, the
We've heard the
question I
cry.
was going to ask is, what's the difference between rent and lease? You had a question signed, but you did
Thank
not
you.
answer that question.
There really is, it's a trick question. There really is no difference. The layman usually refers to a lease as something that's longer term, but they're really the same. There's no difference legally between rent and lease.
Okay. Second question. If I had put my son on a property that I bought for estate planning purposes, and then he's now looking to buy something, we didn't use the housing trust at all. What can be done, or what? Do I take him off the title and?
You're looking to buy something now with
He is now looking to buy something
with
with
NHD.
NHD. He was just put on the title. He didn't had nothing to do with it at all.
Well, as I indicated before, he would now have to go to the NHD. Well, previously, and I heard, well, Sophie has advised me, there has been some change. Previously, the NHG would consider that he has already owned property, and so he wouldn't get his full NHG 6.5 million. They would usually give anywhere between, say, I've seen 1 to maximum maybe 2.5, but not the full 6.5. However, what I'm gathering in recent cases is that he would have to go to NHG, maybe along with himself, I don't know, to establish that the reason his name is already on a title was done as a minor. You were just trying to protect him, you know, that's all. But you'd have to go and establish that for them to make that decision.
Okay.
All right. I have a question here, which could go to either both Senator and to Miss Murray. Can a person adversely possess a property that has a mortgage registered against it?
Sorry. Yes, they can. They can, because remember that the requirement is that the person has to be in continuous. So once you have satisfied those requirements, then you can go ahead, you'll go through the application process, and then the registrar of title will make their consideration. But they absolutely can.
They would have to pay off whatever is outstanding on the mortgage.
Yes, come.
Yeah, go ahead.
Yes, go right ahead.
Okay.
Just state your name and...
My name is Pam Bodden. I'm a realtor.
Come a little closer to the mic.
Yeah, my name is Pamela Bodden.
Lovely.
Okay. My question is, if you own a property, right, via joint ownership, with a child, and you agree to sell the property, how must the proceeds be split? Is it 50-50, or what does the law say about that?
When you say you own it with a child, the child is under 18?
No, over.
It should be split equally. If you own it jointly, it should be split equally. But if the child agrees that you can get everything, then fine, everything can be paid to you. But on the face of it, so yes, you bought this property for the child, and that's one of the reasons why you have to be careful about who you put on your title. The law doesn't care. There are
But
two people on the
paid.
title, it doesn't matter. Doesn't matter if you paid 120%. Two people on the title, it should be split equally. Unless the other party agrees that you can get everything.
Okay. All right. I'm selling a property with a breach, and the breach was made by the developer. Whose responsibility is it to correct the breach?
Once you take it with the breach, once title passes to you, I know.
No, there was a breach.
And that
that's
is
why you
why I
should have
said
done the
surveyor's
surveyor's ID
report.
That's why you should have done a surveyor's
Surveyor's
ID report.
report.
But once title passes to you, it's
So
unfair,
when would you
but it
have
becomes
done
your
the surveyor's
responsibility.
report?
Sorry?
When would you have done this?
When you were
When you were
buying the
buying the
property.
property.
When what?
When you were buying the property.
Oh, you buy
Wait.
from the developer. And
You
then-
should do a surveyor's ID report. Do your own surveyor's ID report.
That's a good thing you said, own, because I've heard of cases where the developer says, yes, man, see the surveyor's report here, everything is clean. But you need to do your own surveyor to make sure, cross-check.
Ms. Gordon,
Just
that
like
is
the
why I
value.
emphasize that at the end, because we're seeing a lot of that when you come to acquire, get a mortgage, or even whatever it is you're doing, get your own independent surveyor's report.
And let me add as well that even if it's a cash sale, we strongly recommend that you still do a surveyor's ID, because once it's a mortgage, you have to do a surveyor's ID report. But if it's a cash sale, it's not compulsory, but we always recommend that you do a surveyor's ID, because as Ms. Finley says, once title passes, then it rests with you.
A question from online. Do I need a lawyer to do a caveat search? Where is the search done?
No, you don't need an attorney to do a caveat search. It's done at the National Land Agency at the Titles Office on Hanover Street. And you could just go to them and let them know you want to do a title search. There's a form that you'll complete to give them the volume and the folder number at minimum. And I think the process is 2 weeks, Cam? And 2 weeks. I think it's 2 weeks.
And you can do it online also. And you can get it right away. And as you said, that's something Miss Morris said. Sometimes a lot of
What
us...
website?
National Land Agency, nla.gov.jm. A lot of times, some of us own property and we don't know how it's owned. We don't know if we own it at all. You don't necessarily, I know it can be an uncomfortable conversation, but you don't necessarily have to ask your partner for the title. A title is a public document. You can go down to the titles office and request a copy of the title. Give them the volume and folio numbers. If you have those numbers, you pay $500. If you don't, just give them the address, you pay $1,000, and you get a copy of the title.
Good evening, everyone. I'm Andre Earl. I want to commend all the panelists on their excellent presentations. Question for the senator and a question for the financier. Senator, you spoke about quite eloquently about this whole matter of adverse possession and taking possession with intent to dispossess the owner and so on and so forth. But I just wonder if you could speak a little bit about the wills and wills line of cases, just a little bit. This whole matter about adverse possession in that situation where one partner can dispossess the other. And for you, the financier, Ms. Murray, approximately, I know we have different ages of retirement. Some people retire at 60, sometimes it's 65. Judges is 72. When you said age of retirement, what age are you referring to? That's the first thing, because you say you don't lend beyond that. And the second question is, approximately how much money does a borrower have to find for your lending institution, not your particular institution, for a lending institution, per $1 million worth of mortgage? Approximately how much? Or per 5 million? So that we have a kind of idea that if we're borrowing 10 million, this is the amount we're looking at per month and so on. But your question was after, Senator.
She wants to go first.
I want to go first because Sophia and I are from the same wonderful institution, sister school to yours. But me being her senior, she'll have to wait on me. So I just wanted to put that out there. Yes, we are Westwood Old Girls. So let me start with the law. You mentioned judges at 72, 65, 60. Those are the numbers that are banded about, whatever the law says. Depending, even if you come at 70, yes, your profession says 72, we're very careful then because, again, yes, as Olive pointed out, persons are living longer, but the time is going to be so short, the payment is going to be heavy, depending on how much you're taking, what's this property you're buying, because the truth, at this point, you should be closing off your mortgage and not taking on a new mortgage, right? We know circumstances change, however, we try as best to say take it earlier so you get the full length and the full gamut. In terms of per million, what we find happening in the industry now is rates vary, one. Two, persons ask also vary, and there are special situations. So I always say choose your partner, and I emphasize it there, choose your financing partner, so you can make a discussion, engage and see how best something can be worked out for you, because not a one-size-fits-all anymore. There are some things that are general, however, most things I'm finding that is happening, and it changes all over, is on a case-by-case basis, because everybody is clamoring for your business. So we're going to try to make it that we win your business. So you go in, you make a case, we're going to try and work out to a solution.
Thank you, Andre, for that very good question, because it gives me an opportunity to talk about something that I didn't mention in my presentation, which is that adverse possession can actually take place in husband and wife situation. In the case you referenced, wills and wills, the wife, I believe, had gone overseas, so she's on title with her husband, and she went overseas for many years, in excess of the 12 years, and at the end of, I think the husband died, and she came back asserting her ownership, and the court ruled that no, her right was in fact extinguished at the end of the 12 years. So though on paper her name existed as the other joint tenant, the fact is that having not paid any attention, having not done anything for 12 years, then she would have lost that right. And as I said, it's so important because when we talk about adverse possession, we sometimes coin the conversation that it takes place between persons who do not know each other, but it does take place between spouses and in family situations as well.
Might I just tack on something that is not financial, but we see it. Whenever anything is going to be done, especially with a matrimonial property, I'm going to ask persons, get yourself involved. We ask at the financial institutions to get what we call a certificate of independent legal advice. Emphasis on the words independent and legal. Too often we see persons waive that right to say, no man, my husband or my wife take care of everything financial and not getting involved. And then when something happens, everybody holds their head and start bawling. never know, never benefited from this money, I don't know what him do with it, or don't know what she did with it, and maybe invest it and I didn't get any of the investment, I'm gonna beg of us. Anything especially happening with the matrimonial property, especially where children and older parents are involved, seek independent legal advice. I beg of you.
All right, a quick question here online. The house beside me is being used as an Airbnb. I am being disturbed by the occupants. What do I do?
That is actually, I laugh because, I know of so many situations where a person have that, particularly in areas where there are these multifamily homes. And my first thing is, in terms of what is on, I'm not sure if it's an apartment, but where you have these multifamily homes, then there are what we call bylaws that stipulate what can and cannot be done. So the first thing would be to check with the bylaws to see what is stipulated on the bylaws, to see if it is in fact agreed upon by all the members that it can not be used for commercial purpose, of which A and B could be deemed a commercial purpose. If there is in fact a provision that it can be used, then my only other recommendation is that you'd have to call the police because it would be a nuisance.
All right. Another question here online. Can you ensure a developer selling a new property in a development is compliant with the regulations to sell? How do you ensure that the developer is compliant before purchasing from him or her?
Well, that's something you need to do before you enter the sale agreement. So you check to make sure they have their building approvals from NEPA, from the parish council, and that they're registered with the real estate board.
Are there plans to update the landlord and tenant law?
Those plans have been in place for the past 30, 40, 50 years. So we still wait for them to be updated, but they desperately need updating.
So who does it? Who is going to take the mic. Remember, there are people online, Holly.
Yeah, the board, the rent assessment board, yeah. Mm-hmm. I would say every 2 or 3 years we hear, yes, amendments are coming to the act, and I think they're still debating it.
But it's crazy because...
It is. Especially with the proliferation of Airbnbs, that's something that needs to be addressed, and gated communities.
And getting people out of your house.
Yep.
Because
it really is unfair. Imagine you have someone in your house, they haven't paid your rent for 6 months, and you have to go to court and go through the process. The act really needs to be updated.
On the question of new developments, we see what has happened in certain communities nearby this one where they have had new developments passed and persons are now swimming to get to their cars. Where does one seek redress when everything it was ticked, it was said they got their approval, and now they're in a situation? Where do we get redress for situations of this nature?
That's twofold, because there are two places you're going to go. The court is one, yes, but also a lot of people are going to turn up at insurance companies and are going to find themselves with zero. Because these are acts of nature, some of them. Some of them maybe you insured but did not insure enough. Again, you insure the property. The financial partner said make sure the insurance for the property is there. But a lot of times we don't insure for the excesses, your possessions, your contents, right? Or you don't insure enough, right? Just give me the basic. A lot of us do that because that's what we can afford. And this is why I said, I've identified this house, can I afford to take on the mortgage and all the other things that may actually come at a cost? And some of the costs you don't expect it now, right? We're not going to go into the newer situations, but you don't know what may very well happen, so have that little reserve fund for the incidentals, please. Yes, Ms. Finlay?
I think.
Oh.
Can I just ask this question, please? And this is very relevant to us, to people in the diaspora, about the taxes. Because one of the things that really worries us, and this is really to the senator as well, and, is for us in the diaspora who pays the taxes on what we call old land. But these old lands has no titles. And we can continue to pay the taxes for family members, and then perhaps when the time comes for the actual thing to be concluded, then we sort of have all this contention. Who do you think is really the actual owners of this property, if you are the taxpayer paying for many years for about 200 acres or less of land?
As I said before, the situation that you've raised is really not unique. So many times we come across clients who have the same concern, that they have been paying the property tax for many years, and then only to find out that someone else owns the property. I will reiterate what I said, is that it has to be more than just the property tax. So if you're overseas, or if you're not in close proximity to the property, you make sure you have someone who goes there, fence the property, cut it, bush it, do something, build a wall, lease somebody, give somebody permission to tie the goat or the cow. Do something that an owner would actually do to show that you're in fact the owner. But paying the property tax alone is not enough to say that you are the owner of the property.
Question here online.
No, sorry. I'm saying if my name is on the title and I'm paying the taxes,
No, not enough.
It's not enough.
Not enough.
not enough to say I'm the owner?
No. You have to do something physical with the land.
Intention is to prevent waste, I'm told. A question here online.
Can I just follow up? These taxes, these lands only has a tax title. It has only has the tax number. It has no title.
It doesn't matter.
It doesn't matter.
It doesn't matter.
Unregistered. A question here online. My father died 6 years ago. My brother is the executor and won't do the probate. What can be done?
You can force him to act. It's what we call citing him to act. If he refuses to act, it's a little more technical, but I'll just try and simplify, then one of the other beneficiaries can jump in.
How does he cite?
It's a formal document that's sent to him, saying you need to do X, Y, Z within a certain period.
This question is for Ms. Murray. I need you to explain the insuring the mortgage, because my understanding was that once your mortgage is insured, you can only benefit, well, you won't benefit from it because it means you're dead. Are you saying then that if my mortgage is insured and something happens to me and I'm unable to work, that they will pay out the mortgage?
It's a life insurance, not a one when some illness comes about.
Right.
So, sorry, go ahead. No, you go ahead.
Oh, I thought that was my understanding. I thought you were saying something contrary to that, though. So I won't have any chance, but my child would not have to worry about paying out the rest of the mortgage.
Exactly. And I'm happy you said your child, because we've seen too many instances where we hear of the wicked financial partners who came and possessed the property that they have a mortgage on, because the mortgage was not being paid and the mortgage wasn't insured. So therefore we take this property, we sell it. So I say to persons, the natural inclination is for you to insure the property. Some financial partners will introduce the matter of insuring the mortgage, and persons will say, I can't afford it, I'm not doing that. When my dad make them take care of that. That sort of we push back. But I say to us, what's for general knowledge, insure, and that insurance, you assign it to the financial institution. So what will happen once you die, and you make that known, again, share your information with your family, who is to know that mortgage is insured, it is insured at X institution. If anything happens, the title is in my top drawer, near the camphor ball, take it out, is the red one, you go there, and they sign over, now they pay out the mortgage. everybody is fine. Free and clear. One of the things I see happening though is that a lot of parents used to put as the note that the child is to get the property at X age or Y age. Because you're also finding when a child possesses a property free and clear too early, willful, easy come, easy go. So some now are saying give them at 21 or give them at 25, or they put different conditions in place to ensure that they are also protected if you are not here.
If I may just add, and I'm not a bank or anything, but one of the things that I've always encouraged clients to do is to just have a life insurance with whoever your broker is, and you assign it to the insurance, the mortgage company. Because there are two benefits to be derived from that, instead of just having an insurance for the mortgage. So that is something that I encourage as well.
Yes, ma'am. Come right.
Good evening.
Good evening.
My name is Foster Shane. My grandfather had his land surveyed in 1894, and that's about 128 years ago. We have been paying the property taxes to this day, but that is not really the problem. The problem is that we're trying to see the title. No one has ever seen the title. Grandfather passed, grandmother too. I don't know if they were joint tenants either, but I would like to believe that since we have been paying the property taxes up to this day, there's some record at the taxes office, the titles office, that would perhaps lead us to this title. And I have been to an office known as Geoland in New Kingston, and they would like us to do another survey. This is quite challenging for us. A survey was done. Why do we need to do another survey? What is informing the payment, what do you call it, the papers that come? Isn't there already a surveyor's report?
That survey would now be outdated. Generally, survey diagrams last for about 7 years. After 7 years have passed, you can update them with a declaration from the surveyor. But over 100 years, that would now be obsolete. So yes, you're still paying taxes. You have that valuation number. Government doesn't care. They want the revenue, so they're still going to be charging you property taxes. But you have to get a current survey diagram to be able to apply for the title. There's going to be no way around that. Have you ever gone to the titles office to do a title search to see if a registered title exists?
Not yet.
You should try. I doubt it. I doubt a title exists, but try doing that. So the valuation number that you'll see on the property tax receipt, when you go to the titles office on Hanover Street, give them that number and ask them to do a search. And that will tell you if there's a registered title for the property. It will cost you $1,000.
Well, could I say that is very interesting, that remark you made about doubting whether there is a title. So what is informing all of these notices that we have been receiving to date?
It would have been that ancient survey. That is what would have established the valuation number. And the valuation number stays with the property for life. But notwithstanding the valuation number, the diagram itself would now be outdated.
Still very interesting. Thank you.
You're welcome.
All right, so we're going to take one more question from the chapel, and I have one more here online.
I am Velma Peart. Following up on her question, my grandfather leave his land to his children. After he leave his children, my father sold us, each of his children, because he said he don't believe in children getting things free. So he sold each of us half acres of his land, what he get from his father. After paying for it and survey it off, we find out that he didn't have a title. He has a diagram. So what we end up with is a diagram. And we can't find the original title from his grandfather, his father.
You don't need the original title. The fact that you would now have been in possession for 12 years, that is what entitles you now to apply for your own title. So you don't need any prior title.
Okay.
All right?
Thank you.
You're welcome.
A question here from online. Do you still have to go through the court if you have in a contract that the renter is to leave X time? And I guess they've refused to leave.
Yes.
Yes. So after the lease expires, then you would serve notice to quit. And if after the notice to quit, let's say it's a 30-day notice to quit, which is the time for you to leave the property, if after that the person is still in possession, you have to go to the court for recovery of possession. If after that they still are in possession, then you'll have to now go back to the court, to the bailiff office for an eviction order.
Which is why the Rent Restriction Act needs to be updated.
There's one last question here on marriage. What if a house was purchased in a previous marriage as joint tenants? I'm guessing one of the spouses dies and the surviving spouse remarries for over 40 years now, and then now is deceased. Is the current wife entitled to anything?
Yes. But yes, it can qualify as her matrimonial home, but as I said before, with this recent case, the Property Rights of Spouses Act doesn't come into play after death, but you can still find other ways to claim it.
Thank you. Ladies, gentlemen, friends, brothers, sisters, we have come to the end of an extraordinary evening. I'm sure we would have many, many more questions. And I was told before that one or two of them may be open to talking to them after this session. They won't charge you. So I'm here now to give the vote of thanks. And first of all, I want to thank the Almighty Lord. He has been with us here. He has kept us at peace. He has guided the speakers. And so we really thank God for his presence and all that has transpired this evening. Secondly, we want to thank the church office for facilitating this evening's presentation. Couldn't stand here without the media, the mics, all the background that was done. Special thanks to Deacon Lawrence Brown, Deacon Michelle Smith, and to Brother Gary Kalam. To our production team, Sister Moya Thomas, Sister Trudy Morrison, and Sister Roxine Nickel. This lovely backdrop, hope I can take one of these palm trees home. We want to thank Sister Margaret Anderson. Of course, the security and our church caretaker, Mr. Vaughn Lynch. Thank you very, very much. And we want to thank everybody who has been a part of the Bethel Legal Aid coordinating team, Sister Sola Hines, and all the members who have been a part of the planning of today's session. So thank you very much, everyone. If there are, as I said, other questions you may have, you can draw on any of the other persons who are here. Have a wonderful evening.